Okay, good morning or good afternoon, everybody. Welcome to today's peer-to-peer workshop that will be conducted by Advocate Hendrik Terblanche. I'm just going to do a short introduction and then Mr. Terblanche can take it away. So, excuse me. So he's the co-owner, managing director, and senior legal consultant at Legricon since 2003 and helps clients with legal compliance through compliance legal registers, conducting various legal compliance audits, and many, many other aspects. He holds a BCom in law through the University of Pretoria, a LLB through the University of South Africa, admitted as an advocate of the High Court of South Africa. So today's topic will be the principles of statutory interpretation. Thank you very much, Advocate Hendrik Terblanche. You can take it away, sir. Thank you.
All right. Thank you very much, Fabian. Thanks for that introduction and thanks for the opportunity to do this presentation. Yeah, so when Fabian asked me to do a presentation on a topic, I immediately thought of this presentation, which is one I did just shortly before the lockdown for a group or a company that acts as professional construction health and safety agents. And as you guys all know, there's obviously always differences of opinion on how legislation should be interpreted and different opinions on the legislation. So I thought it's a relevant topic for anybody in the field because as safety, health and environmental compliance officers and people managers and people having to take responsibility to ensure that our employers and customers are legally compliant. I think there's always these issues that do come up. And yeah, I think nobody said it better than one of our chief justices more than a century ago. Chief Justice Innes said in one court case that no matter how carefully words are chosen, there is a difficulty in selecting language which, while on the face of it expressing generally the idea of the framer of the measure, will not, when applied under certain circumstances, go beyond it, and when applied under other circumstances, fall short of it. So that was the case of Venter versus the state. So I think obviously, one has to acknowledge that there are limitations in words and words can convey different meanings, and the legislator has a certain objective and picture in mind and then uses a word, and then when somebody else looks at that word, there will be some cases where that word will cover things not pictured or imagined by the legislator, while in other cases that word will not cover things that were pictured or imagined by the legislator. The judge also said that sometimes a statutory requirement needs to be applied to a situation that's not mentioned in the legislation, and sometimes it needs to be excluded for a situation that clearly falls within the wording of the provision. All right, so this is the essence of statutory interpretation, that when it ever gets to a court, sometimes they will extend the legislation and say, although this is not specifically mentioned, it should really fall part of it. And in other cases where they say, yeah, it could fall within the definition, but surely it could not have been the intention of the legislator to include that. In another case, the court said that the intention of the legislature can alone be gathered from what it has actually said, and not from what it may have intended to say, but has not said. So that's also important in the sense that, we all maybe have a contact or an idea or spoke to somebody, let's say typically somebody from the Department of Labor that was involved in drafting of regulations, or maybe we sat on some technical committee that advised on the revision of the construction regulations or whatever the case is. And we have some background knowledge on, what were the discussions around the specific provision, and what was the aim of putting something in or excluding something. But at the end of the day, the court will look at the actual words that ended up in the legislation. So that's the only thing they can go on, to look at what the legislator actually ended up saying, and not what we can guess maybe they wish to say, but in the end they did not say it. And then there's also another important concept that one has to bear in mind with this, is that if a literal interpretation could lead to absurd results, such an interpretation obviously should also not be followed. So that is a sort of a final weapon that's often used in court cases, and saying, you can't really look at the words and just follow the words of the legislation, because that could lead to absurd results. But the careful, or the worrying thing there, or the problem with that is, whose definition of absurd. For one person something might be absurd, while for another person it might totally be plausible or acceptable or not absurd. But it is a valuable tool that we use when giving legal opinions and interpreting legislation, is to deviate from the literal meaning of something, to say that it could not have been the intention of the legislator. And one example that we can use there, and you guys, when I look at the WhatsApp group and things, it seems there's a lot of people involved in the construction field and in the construction industry, and the construction regulations obviously leads to a lot of interpretation questions and issues. And if we look at the definition of competent person, and we take somebody like a construction manager, and we see there the definition of competent person says that where there is a prescribed qualification, then or where there is a registered qualification in terms of SAQA, the South African Qualifications Authority, and the NQF, National Qualification Framework, then that qualification shall be deemed to be the required qualification. All right, so now if we look at like I said, the construction manager, there is a registered qualification. You can go and study and get a degree, or a diploma at least, as a construction manager. So now that immediately begs the question to say that, should each and every construction manager appointed in the country have such a qualification? And that's literally what the regulations say. That's a literal interpretation. Yes, the answer is yes, they do need to have that. But I'm sure you will all realize and know that that is not the case. Most of our construction managers do not have that specific qualification. And if you look at the wide scope of construction work, I always use the example of a delivery truck driving through the entrance gate at a factory and knocks down knocks out 2 or 3 bricks out of the boundary wall of the company. So when they repair that wall, put those bricks back, that is construction work. It is repair to a structure, which is a building, which is construction work. Now, to comply with the construction regulations, that is a construction work that requires a construction manager. Are we going to have somebody that's got a degree or a diploma in construction management to supervise that project? And the answer is no, we're not going to have that. And that is a typical example that if a literal interpretation, a typical example of a literal interpretation leading to an absurd result. So I've compiled some directives for any person, even legal professionals, but it's merely aimed at, mainly aimed at health and safety professionals or health and safety officers, managers, agents specifically as well. And, you know, currently with the whole COVID situation, we're all familiar with the concept of directives. When I prepared the presentation, like I said, that was just in the initial outbreaks, and they haven't even started the lockdown yet. So I was using more the Star Trek reference for those of you who are advanced enough in years to remember Star Trek. So the prime directive of the people on the USS Enterprise was not to interfere with other cultures or with the development of other species or whatever. Is just to observe and things like that. So that was the idea. So the first directive that I want to give to people in the SHE profession is do not attempt to interpret legislation. So I always say, always try and look for another way. I mean, there's got to be another way. And the reason why I'm saying that, you will see here, is that even if you get a legal opinion from a lawyer, it's still just an opinion. Even if you get interpretation and an explanation from the Department of Employment and Labour, it is still just an opinion. It's not law. So, I mean, maybe also in reference to the planned discussions that you're having for tomorrow with the Department of Employment and Labour as well, you know, just bear in mind that whatever answer they give you there on how to interpret their directives and instructions and legislation, where it is legislation, is just an opinion. It doesn't mean that that will necessarily be the interpretation that the court will follow. And what we must remember is that only a court of law can give a final interpretation. So that's why I say try and stay away, you know, try and find another way. You'll see there my second directive is, if you cannot resist, if you have to interpret legislation, just always bear in mind in the back of your head that another interpretation may be a valid one, or be valid one, or be one decided by a court. So, you know, if you think about any court case, and I'm sure you've seen these books with the law reports of South Africa and things like that, and you think about the efforts that gone into those court cases, just remember that in theory, at least half of the lawyers were wrong in those cases because they lost. The other half of the lawyers were right, in inverted commas, because they won. So always just bear that in mind. I think this is specifically aimed at agents, and like I said, I see on the WhatsApp group some concerns, and I think we've all experienced that with agents and how they interpret and apply the law. So yeah, I sort of want to try and encourage open-mindedness and saying, listen, you know, your way is not the only way, and it might not even be the correct way. And even if you have all the information to support your opinion, including an interpretation from the Department of Employment and Labour, it doesn't mean that that will actually be the correct legal interpretation at the end of the day, followed by a court of law. So just some Latin. This is also a legal phrase that that we have used to explain. Sorry. I'm just seeing all the WhatsApp, so I just want to make sure there's nothing aimed at me at this point. So this Latin phrase, I think, also sums it up. Quod homines, quod sententiae, basically meaning so many persons, so many opinions. I think, in the health and safety field, we're all familiar with that. We're all exposed to that. Every agent, and I keep on talking about agents, but safety officers as well. I'm sure we've all been on a project or a site or a company where the safety officer makes up his own laws and tells you that the act says this and the act says that. Well, it doesn't. So that is human nature. We're always going to have that. And like I said, in all court cases all over the world throughout history, where statutory interpretation was decided upon, one can argue that one side's interpretation was wrong. So, I think I even wonder at lawyers sometimes that they are so arrogant and confident in saying this is the right way and this is what it means and this is what you should do. I suppose you have to be like that sometimes to convince somebody or your client or whoever that this is the way they should go and this is what they should do or not do. But, I think just a reality check that, it could go another way. So the next, obviously, question that sort of comes up is to ask the question, but when is it necessary to actually interpret? I mean, I really get emails and questions where somebody would ask me, how do you interpret this? And I ask myself, but, is there another way to interpret this? I only see the one way. I'm either missing something or I'm not thinking of everything. But we must remember that interpretation, legal interpretation, statutory interpretation is only required if there are two or more possible interpretations. So if the law is black on white and say, listen, you must do a load test on lifting machinery every 12 months, what is there to interpret? There's nothing to interpret. It's pretty clear. I can't think of another way to interpret. So that's always the first question, is to always ask, but based on what is written there, not thinking about what would they try to say but they did not say, based on what they said, based on what is there written black on white. Is there a different way to possibly interpret this? The other reason, obviously, is what we said, is if a literal interpretation could result in absurd consequences. So coming back to our qualifications for a construction manager, yes, I can't really think of another way to interpret it. The law is quite clear that if we do construction work, and fixing a brick wall is construction work, we need to appoint a construction manager, and that construction manager must be a competent person. And being a competent person means that where there is a registered or prescribed qualification, that shall be deemed to be the required qualification. But as we have said, that could result in absurd consequences. The other example that I often use is, planting a tree in your backyard. Now, in order to plant a tree, you'll probably need to dig a hole. Now, when you dig a hole, that falls within the legal definition of an excavation. And as you may or may not know, the construction regulations say whenever you do an excavation, it is construction work, and it's one of those construction activities that requires notification to the Department of Labor 7 days beforehand. So in theory, I cannot plant a tree if I haven't notified the Department of Labor the previous Saturday that I'm planning to plant a tree this Saturday in my garden. Once again, that is a literal interpretation that results in absurd consequences. I think a court could easily say that could never have been the intention of the legislator to have that as a legal requirement. But in general, as we say, if the language is clear, no interpretation is required. So my first advice and guidelines on interpreting legislation is once again, just read what the legislation actually says. I think sometimes we scan the first few words and we complete it in our heads, or we quickly run with our eyes over the legislation and we miss a little word or a colon or a semicolon or a full stop or something that could actually change the meaning of something. So that's the first advice, is just once again, read with intent and be in the moment and concentrate on what you are reading, that you make sure that you read what the legislation actually says and not what you maybe recall it saying, recall what it said from previously I've read it or heard from somebody else. Right, interpretation rules. So these are the rules used by the courts. And like I said, it's only the courts that can ultimately interpret legislation. But we have to sort of more or less do it at some point, I suppose. So like I said, if you can't resist, if you have to, then these are the things you need to bear in mind. The first and most important thing of statutory interpretation is that all our legislation is subject to the Constitution, particularly the Bill of Rights. All right, so that makes it very interesting in the sense that we have Section 24 of the Constitution saying every one of us has the right to an environment that is not harmful to our health or well-being. And once again, using interpretation principles, that could include our working environment. So we often say, that we have a constitutional, all employees have a constitutional right to a safe working environment. So that means that, health and safety legislation specifically should then be interpreted quite expansively. And by expansively, I mean as an opposite to restrictively. Restrictive interpretation is typically saying, it should be very clear that the legislator wanted to make this a rule. Expansive interpretation says, listen, but if you look at the broader concepts and principles, you should, apply this legislation generally. And, that is sort of one argument that obviously can be used in a court on statutory interpretation on health and safety legislation, is saying, listen, but any interpretation that offers the employee the most protection should be the preferred interpretation, because the employee has a constitutional right to a safe working environment. But then obviously bear in mind that the Bill of Rights and the Constitution is also subject to limitations, and those limitations, we wouldn't have been able to have the lockdown because that would have been unconstitutional. But that was sort of already submitted to the Constitutional Court and saying, based on the evidence and the scenario available, the right to freedom of movement can be restricted based on principles in an open democratic society, upholding fair values and so on. So yeah, we always have to bear the Constitution in mind and bear in mind that everybody has the constitutional right to a safe environment, including a safe working environment. But we must also acknowledge that those rights can be limited also in terms of the Constitution. And then I'm sure that you have heard that the sort of golden rule of statutory interpretation is to ascertain and give effect to the intention of the legislature. So that is what the courts must do. The courts must try and meet the objective that the legislator was trying to achieve. So if you look at the Occupational Health and Safety Act, that little paragraph at the beginning that says it's to provide for the health and safety of employees and other persons and the use of machinery, that is the intention. That is where the legislator, whether it's Parliament or the Department of Labour for regulations, typically tell us what is the aim and the objective of this legislation. And the courts must always try and give effect to that. So once again, when it comes to the Occupational Health and Safety Act, because its intention is to protect the health and safety of people, the interpretation that offers the most protection to health and safety should primarily be the preferred one. So if we are saying, if we have a qualified construction manager supervising the repair of a brick boundary wall, then if that can enhance and better protect the safety of people, I'm sure then that is the interpretation that must be offered. But once again, based on the risks of that project and that type of work, I'm sure a court is going to say, following such a literal interpretation doesn't really further the aim or better ensure the safety of persons at work. So that could also, that same principle could actually be used to say, sorry, no, that was not the intention of the legislator. Another important interpretation rule then is that words must be given their ordinary meaning in the context in which they are used. All right, so ordinary meaning means the meaning that typically people in the street will understand that word to mean. So obviously that could refer to dictionary meanings, and in legal interpretation then people often then refer to dictionary meanings and say, but this is how the word is defined, and that is valid. But it's not just about what is written in the dictionary, it's also how people typically would understand such a word, and in the context in which it is used. So, if we talk about excavation, and we say, okay, what do we mean by excavation? And yes, planting a tree, we could fall in that if we make any indentation in the earth. But if we look at the broader context in which that word is used, in other words, we're talking about construction work and erecting structures and all those types of things. Even the Department of Employment and Labour have then said it wasn't the idea to cover the digging of graves and planting of trees and those types of things in the scope of the construction regulations. The excavation must be related to the erection of a structure, for example. And then also a very important interpretation rule is that we should not go outside the words of the legislations. Like I said, we should really focus on what is written down there in the legislation, black on white, that it's only sort of under extreme circumstances or necessity that one would look at other documents or preceding discussions or anything relating to that legislation. And the the interpretation requirement is also that the words of a statute should never in interpretation be added to or subtracted from without almost a necessity. So that was in Bayard versus the Commissioner of Immigration in 1932. So we shouldn't add words into legislation. If the legislator did not use a word, then we should not add it. Same with subtracting. We should not take any word out of legislation that the legislator has put in, unless it is really necessary, unless it is really like a typing or a drafting error that the provision wouldn't make sense if that word isn't added or subtracted. And then the other interpretation rule is that every word must be given a meaning. Every word used in legislation must be considered and given a meaning. We can't ignore them for convenience or anything like that. So that's another interpretation rule that the courts follow. So just an example that I had, and this was specifically with this specific agent that I did the presentation for. If we look at construction regulation 8.1, it says there, principal contractor must in writing appoint one full-time competent person as the construction manager. And then obviously the rest, as you are aware of. And this particular agent then had a disagreement with the contractor and the principal contractor as whether that person must be a full-time employee of the principal contractor, because the principal contractor wanted to appoint one of his contractors' supervisors as the construction manager for specific reasons. And they then sort of added the requirement to say that, and that guy's name should take out there, the principal contractor must in writing appoint one full-time, and then they put in brackets the employee of the principal contractor competent person. And that is adding words to the legislation. The legislator did not put those words there. So the agent, in order to further his argument in his case, sort of added words to the legislation that was not there. All right, so as we said, there are some situations where one would have to deviate from the literal meaning of legislation. And that would be if words are ambiguous, if it could have two or more possible meanings, then one might have to deviate from the literal meaning. And like I said, in essence, one would then apply the principles of restrictive interpretation. So restrictive interpretation should be applied where the normal meaning of the word stretches further than the legislator intended. And this example I've already used is to say that the definition of construction work includes making an excavation. This would include planting a tree, so we need to give the Department of Labour 7 days notice beforehand. So it's a typical example where literally applying this leads to absurd results, which surely could not have been the intention of the legislator. So you'll see that these ones that we just discussed are interpretation rules. So these are hard and fast rules that must be followed in interpreting legislation. And like I said many times, this is by the courts principally, but if we really have to, then at least we should follow these guidelines as well. Then there are certain presumptions. So a presumption is, it's not a hard and fast interpretation rule, but it is certain things that the courts will presume when they deal with legislation. And as with any presumption, it can be removed or disproven or overruled. All right. So the first presumption in statutory interpretation is that the legislator aims to address general issues and not specific ones. All right, so general issues meaning if we talk about, construction work, it is general, everybody involved in construction work in general. It's not just aimed at people building bridges, or it's not just aimed at people erecting skyscrapers or anything like that. So when legislation comes out, it is presumed to sort of apply widely in the sense that it addresses general things and not specific things. Another presumption is that legislation is not retrospective in application. All right, so this is a very difficult one as well to work with. Also under the construction regulations. I mean, we know the first construction regulations came out in 2003, and then were replaced in 2014. And one of the things that we often deal with there is the post-completion structural inspections. So it says there in regulation 11 currently, or 13, that the owner of a structure must, after completion of the structure, do an inspection every 6 months for the first 2 years, and then yearly thereafter. Sorry, that would be 11 now. And then yearly thereafter to ensure that the structure is still safe and sound. And the question is, does this now apply to all buildings and structures that everybody occupies? And our argument is no. It only applies to structures that were completed after 2003, because this is when it first became a legal requirement. So that is the presumption that legislation is not retrospective in application. It doesn't apply to activities and things that were done before that specific legislation came into force. Another presumption in legislation and in statutory interpretation is that existing law is not affected unnecessarily. All right, so existing law, could mean other regulations of the Occupational Health and Safety Act, common law principles, and those types of things. So the presumption is, the legislator do not generally aim to rock the boat and turn things on its head completely. So new legislation and things must be sort of interpreted, based on what is already in place and what is the existing law on certain things. And then similar with the absurdity is that there's a presumption that the legislator does not intend an unfair or an unreasonable result. All right, so like I said, if you literally interpret certain things, and I think this is more and more obviously the issue with this COVID-19 related legislation, that there's a lot of sort of unfairness and unreasonableness, I suppose, connected with it. So there's not much time to go to court. Things change daily and things like that. But even in the interpretation of that, we must always bear in mind that the legislator probably did not intend an unfair or an unreasonable result. So when the courts interpret legislation, they must also consider fairness and reasonableness. And we often say, the law is not always about fairness. The law is more about certainty than fairness. I mean, we talk about indemnities and the value of that. A lot of people say, yeah, but it's unfair. How can somebody not be held responsible if he just puts up a sign that says park here at your own risk, or whatever the case is? So it's not always about fairness. The law is not really concerned with fairness in many cases. But it's concerned with certainty. So even if a certain outcome is unfair, but it is certain that is what the law is, then fairness will not really be an issue. But in interpreting legislation, that's one of the presumptions that the courts will bear in mind, is to say that the legislator did not mean to make unfair legislation. And as we have said, the rule with absurd results is, it is subjective. What could be absurd to one person could be normal to somebody else. But Justice Innes in that Venter case said, the Chief Justice, that the absurdity must be so glaring that it could never have been contemplated by the legislators. It must really be an extreme case of absurdity, where the presumption would apply that it could not have been the intention of the legislator to include this outcome under the legislation. Further, there's a presumption that the legislator did not intend to make any purposeless or powerless provision. So similar to the interpretation rule that every word must be given a meaning, there's also a presumption that interpretation should be, or legislation should be interpreted in such a way that there's an outcome of it, that a provision is not purposeless or powerless. So that would obviously avoid interpretations that could result in the provisions of the legislation being evaded. And once again, coming back to the construction regulations, if you look at the definition of construction work, the question is then often, that the thing about installation of fixed plant where there's a risk of a person falling. What does fixed plant mean? I mean, I once had to give an opinion on whether the installation of a boiler is fixed plant. And, this purpose, or the one company's argument was that, the boiler is not fixed plant because you can unbolt it from the floor and remove it, and, to me, that would have been an interpretation that really evades the provisions. And it would make that provision of saying that the installation of fixed plant where there's a risk of a person falling is construction work powerless, because I suppose any plant can be dismantled and moved. So that would be an example of that. And then another presumption is that the same words have the same meaning in the same legislation. All right, so if we use lifting machine in the driven machine regulations, there's a definition, and lifting machinery or equipment in construction regulations, but there's not a specific definition there. Then you would use the driven machinery regulations definition of lifting machinery, for example. So that is the other presumption, that the same words in the same legislation have the same meaning. Right, so those are basically the interpretation rules. You see there's very few interpretation rules, about 4 or 5 of them, and then there's about 11 or so presumptions. So presumptions are tools that the courts will use in interpreting legislation. My advice or suggestions or things that you should consider and the way forward is, obviously always consider the merits of an alternative interpretation. So there's also a legal maxim, odi alteram partem, meaning listen to the other person's side of the story. So like I said, this is often aimed at agents. It could be any auditor or whatever the case is. As we say, we have a lot of people working with health and safety legislation and interpreting it. And this is more of a little bit of a sermon to say, just listen to what the other person is saying and consider that person's interpretation as well. Always go back to the risk. So to me, like I said, the prime directive is to avoid statutory interpretation. So look for another way to solve the problem or to solve the dispute. And one question can be, can the risk be addressed also by another interpretation? So when we had the debate about whether the construction manager must be a full-time employee of the principal contractor or not, what is the risk? What does it matter who pays the guy's salary? If we make that person responsible, who takes the full legal responsibility under the legislation for the role of a construction manager, does it really matter if he's paid by the principal contractor or the contractor? And in my opinion, it doesn't. As long as he, has the same responsibility and liability. So in my opinion, the risk is addressed by following another route. And one of the things Fabian also suggested on this topic is saying, but who must appoint who, and who must do what, and all that types of things. And my standard opinion has always been, I don't think that is so important. That is now nitpicking and things like that, which I know auditors do and agents can do, and there's nothing I can do about it. But to me as well, I always ask the question, if something is done, does it really matter who did it? I mean, if there is a health and safety representative, does it really matter whether 16.2 appointed him, or the 8.1 appointed him, or the whatever appointed him. He's there. He is. Everybody knows that is the safety officer. There's no doubt about it. But yeah, we can discuss that a bit later. But yeah, it's always asked what is the risk, and if we have to go to court with this, will we be able to defend ourselves? Doesn't mean the court's going to agree with us or whatever. We might be held liable, but once again, there's very little one can do about that. You can only mitigate the risk as much as you can. And then, like I said, because this was aimed at a specific topic, the question is, between, disputes between the agent and principal contractors and whatever. I think it must always be remembered that the client and the agent on his behalf must discuss and negotiate the principal contractor's health and safety plan. So once again, it's not, my word is law and you have to do it the way that I say. That is not what the legislator intended. And I see the subtext and the prevailing mood, like I said, in the WhatsApp discussions on agents and things like that. But that's not the aim of the legislator. That is not what the legislator intended with this whole system of the agent or the client issuing specifications and approving health and safety plans. It must be a open process of discussion and negotiation. And whenever an agent tries to bully you and say this is the way it must be, you can just highlight that to him and say, listen, but the law says you are supposed to discuss and negotiate with me, not dictate. The law does not say dictate, it says discuss and negotiate. Also, further advice, apply bigger picture thinking. So, I think we tend to focus on one specific section and provision and what it says, but we must always bear in mind the overall scope of the regulations and the legislation and the bigger picture of the construction industry as well. So always consider all impacts, inputs, and outcomes in any statutory interpretation. Because it's costing people money. If you, even as a safety officer or a safety consultant, saying you must do this, you must do that, always try and think of what is the cost impact for the person, your employer or your client or whatever the case is, and ask yourself whether that is true, whether it is really necessary to do it like that, and whether one could achieve the same outcome maybe with least costly means, as is contained in the definition of reasonably practicable. Like I said to these agents as well, I asked them to acknowledge that they do have power in their position, and that power should not be abused, but also that there are limitations. I mean, they are not the legislators, and they are not given free rein to just dictate. There's limitations to that as well. And then, like I said as well, always try to get to a solution without having to resort to legal interpretation. For example, make specifications clear from the start. So obviously, the legislation allows them to issue specifications, and that is typically in addition to what the law says, and that must be as clear as possible. Sorry guys, I just want to notify you, I received a notice that my power might be cut due to them trimming the trees in our area. I see the truck just drove past my gate. So if I do get interrupted, I'll just quickly have to switch on my mobile internet. So if I do get interrupted, it'll just be for a second or so. We're almost done with our time slot anyway. All right, so I think just lastly, I always say to customers that legislation is not written for lawyers, and it's not even often written by lawyers. It's written for industry, for people who need to comply with it. So always say to people, don't feel intimidated to read legislation. Oh, I'm not supposed to give you an answer. I'm not a lawyer. Like I said, even lawyers are not the final say. It's only the court that could finally give a ruling on legislation. Always challenge people to question long established safety mantras. So what I mean by that is, we need to think, of new ways of doing things, and following old cliches and things might not be the solution anymore. Always obviously encourage people not to be too lazy to think. So don't just follow what somebody else said or what you think something says. Think about it. I think that's an important tool in any statutory interpretation, is just a bit of thinking. Don't talk so loud that you cannot hear the other person. So this is also aimed at agents and things like that, to also just listen to the other side of the story. And like I said, if the outcome is agreed on, the means should not matter that much. If we all agree that there should be a person taking responsibility for certain things, how we get to that person and who appoints him and whatever, yes, it might not be 100% according to somebody's interpretation, or actually the literal interpretation of the legislation, but we're getting to the same outcome. And I think that is the question that Fabian also asked. In the time available, I can just quickly discuss that. Something that we often come across is the appointment of construction supervisors and assistant construction supervisors. Now, if you look at the legislation, the construction regulations, it says the construction manager must appoint the construction supervisors. So that means the construction manager is somebody within the principal contractor, but the construction supervisors are people within the contractors typically. So the question is, was it the intention, or that they aim to write the legislation to say, okay, all those appointments must be signed by the principal contractor's construction manager? In other words, one person appoints somebody within another company. Or was it a drafting error where they meant to say that obviously contractors are allowed to appoint their own construction supervisors, and those people will be appointed probably by the 16(2) of that company, because they're not going to have a construction manager. And yeah, I mean, like I said, I have unreliable sources that somebody said the Department of Employment and Labour has said it's an error. They didn't need to write it like that. They meant to say that, contractors can appoint their own supervisors. But that's not what the legislation says. And like I said, the Department of Labour's email or whatever that supports that is not necessarily going to be the deciding factor in a court case. But it could be interpreted as an example of where a literal interpretation could lead to absurd results, meaning that contractors cannot appoint their own construction supervisors, which is a bit absurd. But I mean, maybe, the other hand, there is a reason for that, and it was intentionally written like that. Because a lot of people say, but how can you appoint somebody within another company? And once again, that is not unusual, because, I mean, the main appointments from the agent to the principal contractor, and from the principal contractor to the contractor to the subcontractor, is also one person appointing another company, or a person within another company. So, and it's quite common under the Mine Health and Safety Act as well, where you have to do it, you don't have a choice. It's interesting. So my advice on that specific question, if there is a specific question on that, is I would probably have both persons sign construction supervisor appointments. So I would have the construction manager of the principal contractor signing the appointment letter of all construction supervisors, even within the contractors. And that contractor's 16(2) or whatever will then sign also that same appointment letter as confirmation that even within his own company, that is the person that is appointed as the construction supervisor. Right, guys. So yeah, we've got a few minutes left. I don't know if there's any specific questions or comments.
Hi, thank you, Hendrik. Much appreciated. I think we got time for one question. Unfortunately, guys, we have another meeting starting in the next 5 minutes. So it has to be quick, please, because we have to have this meeting for preparation for tomorrow. So I'll open up for one question. So anybody that, I won't say shouts the loudest, but who picks up their hand first can ask their question quickly. Thank you. I see Alfred, your hand is up. Please, you may ask your question. Alfred? Hi, Alfred, your hand is up. You may ask your question. Go ahead.
Okay. Yeah. Morning, everyone.
Good morning.
Hendrik, I just wanted to find out something on the appointments of supervisors under OSH Act, not under construction regulations.
Yeah.
Is it because most of other companies, they will say you must appoint under Section 8.
A2I, yeah.
And then under Section 8, when you look at it, it doesn't say designate or appoint. It's just the duties of the employer. So
Yes.
can you maybe just clarify on that one?
Yeah. Okay. Yeah,
and also,
yeah.
just a quick follow-up on that one also. And the appointment of the risk assessor under OSH Act, let's say people who are working in buildings, not in construction, because under the OSH Act, it's not specific on where the risk assessor must be appointed.
Yeah. All right. So, yeah, thanks for that. So I'll start with the second one first. You're 100% correct. There's no general requirement under the OSH Act to have a risk assessor and to have a risk assessor appointed. If you look at and you know, that's why I also don't really like the construction regulations approach, because I think we all in the profession know that risk assessments are better done by teams and not by a single person. So there's various references in the legislation to say that the Health and Safety Committee and the Health and Safety Representative must be consulted on the assessment of hazardous chemical substances and noise exposure and all those types of things. The OSH Act also says we must involve employees before we respond to a risk. So yeah, there's no requirement, and I don't actually like the requirement of a risk assessor appointment under the OSH Act. Because that's not the way it should be. The employer must ensure that those risk assessments are conducted, and that would be the CEO, 16.1 and 16.2. And they can obviously delegate tasks to a risk assessor, so to speak, to coordinate the activities and to facilitate the risk assessment. But yeah, it's not necessary to have such an appointment, and I actually wouldn't encourage to have such an appointment because I don't think it's a particularly good appointment. On the A2I, the supervisors also, I feel quite strongly about it that Section A2I of the OSH Act shouldn't be used as an appointment, because I've seen companies abusing it. I've made findings recently on companies where they use Section A2I as an appointment, and they just copy and paste the whole Section 8 duties, which is a 16.2 duty for the A2I. And that leads to the ironic situation that the A2I must ensure that there are competent supervisors on site, but he is the competent supervisor. So you point out that circular argument and say to people, you know, but you can't appoint somebody as an A2I and then give him the duties of Section 8, which includes Section A2I. So companies have used that, but I don't like it. So I don't like it. So first question is no, there's no legal requirement to have such an appointment. So nobody can make a finding that you don't have such an appointment. And secondly, I actually don't like it when companies use it as an appointment. If you use it as an appointment, the important thing to note is that all your supervisors must then get that appointment. Because I sometimes see people, they're selective and they say, okay, this supervisor, and that's not what it is. You know, this is now the Section 8.2I is a duty on the employer to ensure that supervisors are competent and that they are given the authority to enforce the safety measures of the employer. If you selectively say, okay, but this supervisor, he is an A2I, but that one isn't, that goes against what the legislation is. All supervisors, according to Section 8.2i, must be competent, and they must be given the authority to enforce the health and safety measures of the employer. So it's not really an appointment, it's maybe just a notification to say, listen, because you are a supervisor, and I always say all companies have supervisors. So that's a normal company structure. So you can tell those supervisors and say, because you are in a supervisory position, you have the authority to enforce the safety rules. So you have to stop people who's not working safely, and you have to, supervise and enforce. But also very important, it remains an obligation on the employer not to put somebody that's not competent in a supervisory position. And by competent, we mean competent from a health and safety perspective. So that to me is the important part of Section 8.2i, saying, okay, before I promote somebody to a supervisory position, I must really be confident that that person understands the hazards in that area or for that task, and that would make that person competent.
Oh, okay. Thank you very much once again, Mr. Hendrik Terblanche. Thank you for your time and efforts. Thank you everybody that's joined in today. We really appreciate the support. If you have any additional questions that we can take offline, please WhatsApp them to me, and then I can speak to Hendrik on the salient questions, and then I can give you some responses as well. Thank you very much, everybody. Enjoy the rest of your day, and take care and stay safe.
Okay.